The moment a body is found, the clock starts ticking. 48 hours before the trail goes cold. From A&E and Crime House, this is the official podcast from the famous true crime series, The First 48. I'm Carter Roy. Every Thursday, I revisit a landmark homicide investigation in depth with long-form storytelling built for your ears. Listen to and follow The First 48 on Apple Podcasts, Spotify, Amazon Music, or wherever you listen to podcasts.
I'm Alice.
And I'm Brett.
And this is The Prosecutor's Legal Briefs. Welcome back to The Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined as always, by my deja vu co-host, Brett.
You know, Alice, there's nothing new under the sun, right? I mean, that's what the Bible says. That's definitely right when it comes to true crime.
That is true. There are times where I'm like, haven't we been around this hamster wheel again and again and again? And the answer is yes, but it keeps coming back and it's still interesting and it's still in the news. And so we are updating. And of course, even though we're recording this on a Sunday, true crime news has just been through the roof the past couple of days, you guys. Our old friend Creighton Waters and Pootie Poot have been back in our lives with Murdaugh, trial number 2 getting scheduled. They were, I mean, truly, well, I know we'll talk about this. I know you feel the same way, Brett, but it was like old friends as we watched the pretrial hearing. A lot happened there.
Yeah. And let me just say, I know this makes me a bad person in some ways because that obviously was a terrible crime. Son was murdered by his father. A mother and wife was murdered by her husband in such absolute cold blood. Terrible case. But man, it just makes me happy to be. It feels like old times. It feels like such a simpler time back when we were doing Murdaugh.
It was just a child murder where you could really hate the dad for doing it. You know, and like the evidence was all there. No conspiracy theories about it.
Yeah. And the conspiracy theories were kind of dumb.
Don't worry, we get to go back.
Nobody believed them, you know. But now, it's a different time. So.
Different time. And then, of course, we also have today, we told you we'd talk about it, if he pled guilty, and he did. Kind of out of the blue, without a plea agreement. Mr. Luigi Mangione pled guilty in federal court and is now challenging whether the New York State trial for second-degree murder and weapons charges can go forward. And a lot of you are asking questions about, like, what? Double jeopardy? You've always told me state sovereign is different than the federal sovereign. So what are we talking about with double jeopardy? Don't worry. That's what we're covering today.
Yeah, and I just want to point out, we told you we would cover this when he pled guilty because we made clear he was going to plead guilty. I like to claim our wins when they happen. You know, we miss a few, so I got to take the wins when we get them. And this one was pretty obvious. Once his motion to suppress was denied, he was going to plead guilty, and that's where we are.
Right. And now, I don't know if we predicted this, but I would have absolutely predicted it was going to be federal, even before I knew about the New York Constitution's extra protections when it comes to double jeopardy. And that's because typically when it comes to sentencing, you're not getting tried for murder straight up in federal court. And here he's being charged with stalking with the purpose of then ending in death. But Mangione was initially charged with 4 counts. Interstate travel for the purpose of stalking Brian Thompson, causing death in violation of 18 U.S.C. Section 2251A1A and 2261B1. Number 2, use of electronic systems for the purpose of stalking Brian Thompson, causing death in violation of 18 U.S.C. Section 2261A2A and 2261B1. Third, murder through the use of a firearm in violation of 18 U.S.C. Section 924J and the use of a firearm equipped with a silencer in connection with the crime of stalking in violation of 18 U.S.C. Section 924C. These latter 2 charges fell away because of the really absurd categorical rule. So really, it's just the stalking charge causing death and then using an electronic system for the purpose of stalking. So really 2 stalking charges.
And look, We talked about that in detail. You go back to some of our Luigi Mangione discussions on Legal Briefs, you can hear all about that and why it happened. Like, there was some joker on Twitter who was trying to say he's going to get an easy sentence because the judge is defense friendly, and we know that because she dismissed these charges. And it's like, you don't even know what you're talking about. You didn't even read that opinion, did you? Because she was angry. You could tell she was angry that she had to dismiss those charges because of this silly, stupid Supreme Court BS that they still haven't got rid of, the categorical rule, the worst rule in all of the law. And I'm not going to dwell on it because I've dwelled on it before. If you want to hear my rants about it, you can go to the previous episode. But that's the situation we're in. He's got 2 counts left. And as Alice said, he's not charged with murder in the federal system. This confuses some people. It always confuses some people. So we always just want to remind you there's no general murder statute in the federal system. So you do have a federal murder statute, 18 U.S.C. section 1111, but there's only a very few narrow circumstances in which that applies. And that doesn't include this particular homicide. This homicide would not fall under that murder statute. So they had to be a little bit more creative. And so they do this stalking resulting in death. People keep saying he pleaded guilty to stalking. And that's true. But the causing death part, death resulting part, really important, as you're going to see from the sentencing guidelines when we get to them. So he enters into an open plea to these counts. And I just want to address something right off the bat, because there are a bunch of people on X who were saying, oh, the government completely messed this up. How could they let him plead guilty? Now he might benefit from this double jeopardy statute. You can plead guilty anytime you want. We talk about this sometimes in our jobs, the race to the courthouse. Like, there are times, for instance, where defendants want to plead guilty in state court, and we're like, calling up the prosecutors, local prosecutors, asking if they can try and continue the hearing, get it past a certain point so we can move forward with our thing. But at the end of the day, once you indict someone, they can plead guilty whenever they want. That's the whole point.
They can do it on that first arraignment.
Yeah.
You know how we always say people always plead not guilty because you want to get the discovery, you want to like figure out if you have suppression motions and other legal action before you ultimately do the change of plea and plead guilty? You can plead guilty as soon as you're arrested. No one's preventing you from doing that.
You can plead guilty from the moment you're arraigned to right before the jury foreman says the words of the verdict. You can plead guilty. That is, you're absolutely right throughout. If somebody wants to write in with some way that prosecutors can keep someone from pleading guilty other than by dismissing the indictment, feel free. I'd love to hear it. Give me your argument. So there's no, the government messed this up. Now, I will say this. The state and the federal prosecutors have been adversarial this whole time. They're not working together. It's embarrassing,
Which is
frankly.
Really not great practices.
No.
Just because you want to be able to work, especially if it's the same nucleus of facts, you don't want to be in tension with each other, obviously.
And they haven't done that, and that didn't cause this, but it's just unfortunate to see it. Anyway, he pleads guilty. It's an open plea. There is no plea agreement here. The government didn't agree to anything. There's no deal on a sentence. There's no dismissed charges. He walked in and said, I'm guilty, and that's what he can do. So that brings up the question of what is he looking at? Because as we said, there's going to be this whole issue about whether he can even be charged in state court. So this is where the sentencing guidelines come in. The sentencing guidelines are not binding on a federal judge, but most federal judges take them seriously. Judges can vary up, they can vary down, depending on whether or not they think the guidelines appropriately reflect the seriousness of the crime. And there are 2 things about the guidelines that are important. The total offense level, which is about the particular crime with which you have been charged and convicted, and your total criminal history, which can include you had a DUI when you were 16 or something like that. It goes all the way back and incorporates all your different history. So this is a case where the ordinary stalking guidelines are not going to apply. I think stalking starts off at like a 17. You know, you plead guilty to stalking, you're probably looking at, I mean, I could look it up. So if you plead guilty to stalking, you're probably looking at, if you plead guilty and you have no prior criminal history, 24 to 30 months. So 2-year sentence, right? He is not going to get that guideline. There is a cross-reference in the guidelines that basically says, if the thing you did cross-references to a state murder charge, act accordingly. Here, the cross-reference would be to premeditated murder, first-degree murder. So if you go to that section of the guidelines, which is 2A1.1, that puts you at the highest possible offense level of 43. So with a 43, the guidelines range, regardless of your criminal history, is life. So based on just that, if that was all we were going to look at, he's looking at a guideline range of life. And to get anything less than life, and remember, there's no parole in the federal system, the judge would actually have to vary down for him to get that.
But he did plead guilty, so he will get acceptance of responsibility, and that's 2 levels off. So just by pleading guilty, that's accepting the responsibility, and the guidelines recognize that and give you 2 levels down. So the government would give him another level for pleading, but they could do that. So you can get a 3rd point, usually when you're like working in agreement with each other. I think they had been discussing a plea agreement and they never reached one, and Mangione went ahead and pled guilty. So they don't have to. It's discretionary to give a 3rd level down. I don't think they'll do that here. So that's base, and we know this because of what they will say about this recommended sentence later. So that's base offense level under section 2A1.1, which is a 43. Acceptance under 3E1.1A, which is -2. So taking down the total offense level to 41. And then he has a criminal history category of 1 because he has no criminal history. So when you cross-reference that chart, 41, total offense level, criminal history category 1, that brings you to 324 to 405 months as the guideline sentence. So at a 40, if the government gave him that 3rd level down, it's 292 to 365 months. Now, those of you who haven't been here long, haven't listened to our federal sentencing guidelines episodes, you can go back and listen to that. But that doesn't have to be his sentence. The guidelines are advisory. This is to help guide judges on what this type of case puts you in, but the judge can vary up or down. And because there's no plea agreement, the government doesn't have to ask for a guideline sentence. So oftentimes when we reach plea agreements with defendants, usually what we're agreeing to is we will ask for a guideline sentence. Or if it's like a very favorable agreement to them, we'll ask for bottom of the guidelines. We'll ask for just 324 months instead of the top end of the guidelines, because the judge does take into account what the prosecutor thinks is an appropriate sentence here. And so the federal prosecutors came out and already said on Friday after he pled guilty, oh, well, we're going to ask for life, which is allowed under the statute. So they're not going to ask for a guideline sentence. They're going to ask for life here.
And look, it's an easy argument because the judge had to dismiss counts that carried the death penalty because of a quirky procedural constitutional rule that she doesn't like. She didn't like that. So all you got to do is walk in and say, look, Your Honor, because of Supreme Court case law, we had to dismiss those other 2 counts. We lost the death penalty, and that's fine. That's what the Supreme Court said. That's the law. That's what we have to follow. But when you're thinking about the guidelines, that dismissal means the guidelines are not fully capturing the conduct here. The conduct here alone, without the categorical rule, would ordinarily call for the death penalty. That's what the conduct would call for. He's fortunate he's not getting the death penalty. That's not going to happen to him, but he deserves life, and you should give him life, and that's going to be their argument. And I don't know if the judge will give him life. I think she's going to vary upward either way. I think he's getting at least like 480 months, like a 40-year sentence or something like that. I think there's a strong possibility he will get life. Given what he did, he stalked this man.
Given how the judge feels about dismissing those 2 charges, right? I mean, she recognized the seriousness of all of this, and she wrote a very good opinion behind her thinking, but like a good judge, followed precedent as she has to do as a lower court judge.
So I think they got a really strong argument. Prosecutors have a really strong argument here. I don't anticipate this is going to be a guideline sentence. I just don't think it will be. I think she's going to vary upward, and it's going to be very well supported. You can challenge those variances. You can say the sentence is unreasonable, but that's going to fail. It's not going to be an unreasonable sentence. So I think he's probably going to get life. And if he gets life, then frankly, what's happening in the state court doesn't even really matter at all. But let's assume that we're wrong. Let's assume the judge is like, you look like such a nice young man, Mr. Mangione. So even though the government's not asking for that point, I'm going to give it to him anyway. And I'm going to send you at the bottom of the guideline range. I'm going to give you 292 months, which is what? 25 years, basically. 25 years in prison. Let's say they do that, and the New York prosecutors are like, that's not enough. We are charging this man with murder. We don't have the death penalty, but we got life without parole, and we're going to go for that. Well, that's where double jeopardy comes in. And that's where his lawyers, fantastic job in this case, by the way. Incredible job. They defeated the death penalty in a very legally sophisticated argument. Those are tough arguments to make and tough arguments to win. They defeated that. They made a really smart call about pleading guilty in federal court because guess what? Worst case, he's in federal prison. You know, would you rather be at Rikers Island for the rest of your life or some cushy, medium security? He's probably at least medium security given his crime. Maybe even high security. Prison, nevertheless, federal prison somewhere. Which would you rather be? Most of us, I think, would rather do federal prison. And basically every criminal would rather do federal prison. So very intelligent. Because he pled guilty there first, he will end up in federal prison first, regardless. So he's going to serve most, if not all of his time in federal court. Now, I will say one thing about this. The way this works in this particular circumstance, if he is eventually convicted in state court, it will run consecutively, not concurrently. So it won't run at the same time. He'll have to do his federal time first. It will not count towards his state sentence. And then he would have to go to state custody. So that's one reason the state of New York is interested in doing this, just to make sure he doesn't ever get out. But his lawyers, smart guys, have moved to dismiss those claims based on double jeopardy. Now, Alice has already said it. Some of you are angry. You're like, what are you talking about? You've told us so many times. There is no double jeopardy when you're charging in separate sovereigns. And you're right. There's not, according to the federal constitution, which is another reason it was really smart to plead guilty in federal court first. Because if he'd pled guilty in state court first, the federal courts would have said, double jeopardy? What are you talking about? Doesn't exist. But by pleading guilty in federal court first, he is able to avail himself of the higher protections in state court. Once again, as we've told you 1,000 times, in our great country, 50 laboratories of democracy doing their own thing. The United States Constitution sets the floor, but not the ceiling. If you want to give more protections for people in your states, you absolutely can do that. And that's what we're seeing here. New York protections on double jeopardy are broader than the federal constitution. And generally speaking, New York will not prosecute someone for an offense arising from the same act or criminal transaction that has already produced a conviction in another jurisdiction unless one of several exceptions applies.
Insurance isn't one size fits all, and shopping for it shouldn't feel like squeezing into something that just doesn't fit. That's why drivers have enjoyed Progressive's Name Your Price tool for years. With the Name Your Price tool, you tell them what you want to pay, and they show you options that fit your budget. Enough hunting for discounts, trying to calculate rates, and tinkering with coverages.
Maybe you're picking out your very first policy. Or maybe you're just looking for something that works better for you and your family. Either way, they make it simple to see your options. No guesswork. No surprises. Ready to see how easy and fun shopping for car insurance can be? Visit Progressive.com and give the Name Your Price tool a try. Take the stress out of shopping and find the coverage that fits your life on your terms. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law. Guys, do you love finding a good deal? One of my formative memories in life was going with my mom shopping. We would go to these outlet stores that had all these great products that you could buy for cheaper than you could ever imagine. And my mom was always looking for a good deal. And I grew up thinking that is a good thing. And you know what? It is. And now in the modern day, when you're looking for a deal, you should look to Whatnot. It is an app that focuses on community, on deals, on being a seller yourself, and enabling you to find all the great brands that you didn't realize had great deals. On Whatnot, you're connecting with sellers and other shoppers. It's like hanging with the group that gets you. This is a fun way to shop, and you almost never pay full price. You can shop name brands across makeup, perfume, clothes, handbags, jewelry, and more, all without the retail sticker shock. This is the best place to find great deals on the products you love.
Guys, I love shopping. I love a good deal, but I'm also really busy, so I don't really get the live shopping experience that I just crave until Whatnot. This is where shopping happens in real time with real people, real conversations, and these incredible deals. Okay, I like nice things, but let's be honest. I have lots of kids I have to feed, so I can't really afford to pay top price for it. I wanted this beautiful designer bag, and I thought, let me just check Whatnot for it. Not only was it on Whatnot for literally half of what it's going like right now on other sites, I got to watch the seller show me close up everything about the bag. I got to ask questions to a real person about the bag and its condition. I knew exactly what I was getting, and I was thrilled. Download Whatnot today and get $20 off your first purchase. Search Whatnot, WHATNOT, in the App Store, sign up, and start finding the best deals on the products you love with $20 off your first purchase.
Sleep Number's new collections are designed to adapt to the changing nature of your life and your sleep needs. Whether it's the personalized comfort of the Comfort Mode mattress, the targeted pressure relief of the Comfort Next mattress, or the Climate Collection that actively cools or warms to help you fall asleep and stay asleep.
And now, all beds are on sale during our biggest sale of the year. Save 25% on the new Comfort Next Luxe, plus free delivery on any mattress. Ends Monday, only at a Sleep Number store or sleepnumber.com.
So, the state case isn't automatically over. Prosecutors can argue that the federal stalking offenses and New York's murder and weapons offenses contain different elements. And this is somewhat stronger of an argument to make because those other two charges had been dismissed in the federal court, which were murder and firearm charges. So they can say that they're not only different elements, they address different harms, and they fall within another statutory exception. The court will therefore have to examine each state charge separately to determine whether that statute is part of New York's unusually broad double jeopardy statute. So the weapons charges are almost certainly not precluded. And he has a better argument, though, on the murder count, since it's not just stalking, it's stalking resulting in the death. So it's possible that it may just go forward on the weapons charges, which isn't going to give you that life sentence, likely. But if these are going to run consecutively, there's like justice in New York. And if he gets, say, something like only 25 years and you tack on another 20 years, that gets you closer to maybe what justice should look like.
And I think people who've talked about this have really missed this fact. He is not just charged with murder in New York. He's charged with all these weapons charges as well because of the weapons he had and the particular statutes in New York that address them. And the thing about it, New York's double jeopardy law is really designed for you got convicted of fraudulently selling real estate in federal court, and the New York wants to bring the exact same charges. Imagine a Murdaugh situation. This actually came up with Paul Manafort in New York, but imagine a Murdaugh situation, which we're going to talk about in a second. Remember, he got hit with all his fraud counts in state and in federal court. He got hit with both, charged with basically the exact same transactions, violating the exact same types of law, one in federal court, one in state court. In New York, can't do that. Once he pled guilty to fraud in federal court, he's out in state court. This is a little different. Yeah, I mean, it comes from the same transaction, but the stalking resulting in death is a little different than the murder charge itself. There are similarities, obviously. There's an argument, a good argument his lawyers can make, but I could see just the fact that there are different elements, there are different types of charges. Murder is about death. The resulting in death is sort of an add-on to the stalking for sentencing purposes, right? So it's a little different there. The result, though, is the same. I think his lawyers can argue that. Like, even if it is a sentencing add-on, it's a sentencing add-on that takes you from 2 years to life. Pretty significant sentencing add-on. They have that. Weapons charges are going to completely lose. There's just a completely different thing. It's even if he hadn't killed anybody, he would have been guilty of that. And we want to prevent people from having those kind of weapons in New York, all that sort of stuff. So I think they'll survive on that. Honestly, I think 60-40, they'll survive on the murder. Maybe even 70-30. If we even get there. They want to have this argument before sentencing, which is kind of interesting. If I'm the state court judge, I'm continuing the trial because I think the trial is currently set for before sentencing. And I'm saying, I'm not addressing this until I actually know what the sentence is. I'm just not going to waste my time and your time and my energy.
And December. So it's not, I think it's like a month or two after the scheduled trial. So we're not like pushing it out that far. And it is obviously going to affect the New York prosecutor's decision because we don't want to waste court resources here if we are just arguing semantics.
Now, here's one way this could have been different. If the feds and the state had been on the same page, working together, they could have gone to Mangione and probably come up with some sort of deal. It might not have been life, but it might have been 50 years in federal prison, something like that, something very significant, where he at least has the glimmer of hope of one day getting out. They didn't do that, so we're where we're at with sort of the wasting of resources, but they should have at least tried, and they didn't do that. And so that's where we are, and if the judge decides to move forward this and we have a whole bunch of arguments and a bunch of time wasted, congratulations, people of New York. You'll just pay for that. And then you might get sentenced to life anyway in December. And there you are. The other thing, honestly, when I think about this, if I was the defense, I would probably want to wait as well. Because if you win in state court before the sentencing in December, even if the judge doesn't officially take that into consideration, it might be in the back of her mind. Whatever I give him is what he's getting. So that might affect their sentence too. So there's a little bit of strategy to be played out there about how it's best to approach that. Anything else on Luigi before we move on?
You don't have to say anything when you plead guilty. You have to take responsibility, but he did have a prepared statement where he said more than honestly a lot of people who plead guilty say. And, you see all these headlines saying he gave his motive. I mean, we knew this before. He said that he had suffered from back injuries and that he was in a lot of pain and that he deliberately reached out and basically catfished Brian Thompson to figure out where he was, showed up and he killed him and he knew it was wrong and he did it anyway. So he did claim responsibility for it. There's no secret as to why he did it. I think he said it because he has this entire following of people who are so on board with this mob killing that we do not stand for in a country like ours that believes in rule of law. So I think part of this wasn't so much unloading the burden from his guilty conscience, but rather leaning into this entire movement that applauds him for his assassin style killing for a man who did not operate on him, did not treat him, and probably didn't personally deal with anything of his healthcare claims. So that's my cynic in me as to why he said what he said during his allocution.
Well, if Lindsay Clancy has taught us anything, just because you said you did it repeatedly and explained exactly how you did it and why you did it and what you said when you did it, doesn't necessarily mean you did it. So maybe he's actually innocent and we'll never know.
And maybe this is his plea. Did you see the times he blinked as he said it? He was under duress because I think the New York prosecutors probably 3D printed the silencer and the gun. And they were making him do
check
this.
His blinks for Morse code?
Yeah, I don't know Morse code, but I felt it in my heart and it said SOS. It's not probably what he actually did it, but we connected.
Somebody cut that and put it on TikTok. We're going big. That's our new theory.
It was definitely SOS. Again, I don't know Morse code, so I can't confirm it, but I felt it deep within my bones of justice that it was SOS.
All right.
So with that case, let's move on to our old favorite, Murdaugh.
Old favorite. Murdaugh was back. Pooty Poot was there doing his thing, man. Pooty Poot, I feel like he's like a fine wine. He just gets better with age. His little quips just...
this was a fun hearing. I'm not going to lie.
I selfishly just can't wait for this.
It was like, what did I text you? I was like, this is just a fun game of throwing crazy spaghetti at the wall. That's what the hearing was.
Absolutely. So it was a big week. Had a big hearing, big pre-trial hearing. We're in front of a new judge. We miss the old judge, but he is retired.
I hope he enjoys retirement.
Yeah, he's probably like, I'm so glad. Not doing this again.
Poor guy. He truly deserves good retirement, but we are not going to be let down with this judge.
No.
I like her.
I think
her a lot.
Deborah McCaslin is going to be pretty awesome. It should be fun seeing her and Pooty Poot go back and forth together. She seems to be pretty no-nonsense. This hearing happened on August 14th, and she issued several important rulings. one which I don't think any of us were surprised by. We talked about this when the case got overturned. Where in the world are you going to try this case? Everybody in Colleton County knows about it.
Not Colleton County, not where Ms. Becky Hill was the county clerk.
No. Everybody in the circuit knows about it. Honestly, they probably shouldn't have tried it there in the first place. If they hadn't tried it there in the first place, maybe none of this would have happened. But nevertheless, so we're not trying it in the 14th Judicial Circuit for obvious reasons. There was extraordinary publicity before. There's even more now. Now, look, can you find a place in all of South Carolina that they hadn't heard about this case? Probably not. But at least it's not as personal for people maybe in Charleston, which seems to be the place the defense wants to go, despite flooding came up some. You know, it's weird.
Fancy restaurants that they're not going to go to because he's broke.
And it's going to be expensive.
It's going to be so expensive.
Costs.
I was like, wait, do you want to go there or not?
I know. It was kind of funny because
I was very confused.
I think they were sandbagging it. They were like, oh, Charleston. Oh.
Why would we want to go there? But and they put their own person. Was it an attorney or an intern that they put on the stand that was like, there's no parking at the courthouse in Colleton County.
You know, it was so funny because I'm sure Pootie Poot hated being stuck in Colleton County for that trial. And he's like, thank the Lord, we're going to be somewhere else.
We're going to eat like kings every night in Charleston. Can you
imagine what it's going to be like if they go to Charleston? Pootie Poot will be the man about town. He will be out every night at the fanciest restaurants, drinking, eating shrimp and grits. He's just going to be
taking pictures next to cannons with tourists who are in town to watch this.
Oh, yeah. It's going to be amazing. So they're moving it. Now, we don't know where it's going to go yet. Charleston came up a lot. Kind of feel like maybe that's where it'll end up being. I hope they send it somewhere completely random, you know, but probably Charleston. The state's proposed several other counties that they think would be better. And look, the things you look at, you do look at cost. You look at travel time for witnesses, for the state's witnesses, for the defense's witnesses, the experts, all that kind of stuff. The jury, I mean, they're moving it out. This is, you know, sometimes they do the thing where they bust the jury in. They actually have it in the county. They did that, I think, in, what's her name, in Florida, Casey Anthony. They bust that jury in, but they kept it there. Sometimes you do that. So we'll see exactly how they work all this out. But here's the thing that won't happen. We're not going to have a Colleton County trial with a Colleton County jury. That's not going to happen.
No. And I was going to say, I can see them moving out of Colleton County just because Becky Hill, like the staff is also part of this, just her, but having the whole staff go through this again.
And I just do want to say, people in the chat have already mentioned this. If they do this in Charleston, thinking this might be a business trip we need to take.
I'm just saying.
For the good of the podcast.
Have you been there?
I have.
Everything Pootie Poot was saying was right. They have great restaurants.
We could hang out with Pootie Poot every night. We could do
We could buy him a dinner because he said his client is broke. He can't afford dinner. We'll go to dinner. He'll tell us the down low. And maybe we keep him out a little too late so he's late for court in the morning.
Yeah. Can you imagine? Every night. Prosecutors and Pootie Poot.
Oh, prosecutors and Pootie Poot. Oh, my goodness. That would be really fun. Charleston is an awesome city. I really like this judge because not only is she no nonsense, she moved through, there were a lot of motions and she was upfront what she was going to deal with, what she was going to wait until later, and it all made sense. So she didn't beat around the bush. She ruled on something that, I'm not patting ourselves on the back, but we definitely called this. The question was whether the prosecution could use Murdaugh's testimony from the first trial, because remember, he took the stand for many hours in his new trial. And the answer was yes, of course he can. But remember, the South Carolina Supreme Court said that the prosecution was allowed to go into the financial crimes a little too much. Like they could show some for motive, but what they did was too much. So we don't know where the line is going to be, but it's going to be something less than what they did in the first trial. But financial crimes will still be able to come in to some extent. So the judge said, yes, you can use his testimony from the first trial as it is relevant, which is always the case. If it's not relevant testimony, it doesn't get to come in.
And I just want to say, number one, I'm going to pat ourselves on the back because so many people push back on us for this. You know, you guys out there, I love you, but y'all were citing all these South Carolina Supreme Court cases that weren't relevant about prior testimony. And it's just obvious that this was going to come in. The defense made some good arguments about it, but you can't have prior statements of the defendant that don't come into a trial. Now, one thing I think the state needs to be really, 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 really. Because that many reallys, it's like very. If you say very, it makes it more serious. If you say very, very, it's very, very serious. So the one thing they need to make sure they do, be very careful about how you use this, because this is a fine line to walk. How much you push to use that prior testimony. If I would say, however far you think you can go halfway. The last thing you want is for this going back to the Supreme Court and the Supreme Court saying, we said y'all had to be careful about this financial crime stuff. And you used this testimony from him before where he said X, Y, and Z, and that was too far, and that undermined the entire trial. Whatever you get in about financial crimes is great. His words about it aren't even really that important. So I just would be really careful about what they use there. Focus mostly on the stuff he said that indicates he's guilty of murdering his kids. The financial crime stuff speaks for itself and is important, and it will come in because it speaks to his motive. But I just think they need to be careful about how far they push that.
Agreed. And then, in the least important ruling of the day, the defense won permission to send the remaining material recovered from beneath Maggie Murdaugh's fingernails to Othram, which is a private Texas lab for independent DNA testing. We've been to Othram before. Incredible work that they're doing. But if you remember the DNA, I think, what was it, like 99% Maggie and 1% unidentified man? Like, it was nothing, right? This is not going to be a gotcha moment. But to their credit, they're picking like the best of the best. The judge says, yes, you can send it off for testing, but there's going to be safeguards that's going to be geared at intending to preserve the limited sample that's left, because we've said it, once you burn it, it's gone. So whatever sample you have left, you have to decide, is this worth burning at this time? And then whatever results they get, they have to share it with SLED.
And Othram's the ones to send it to, because we
They'll
went
tell
to that.
you if they can't.
Yeah, we went to that thing in Othram in Houston, and their headquarters in Houston, and they took us on a tour and showed us all the various things and the way they do stuff. Absolutely incredible what they're doing. But one of the most amazing things they do is they will not, and this might sound like common sense, but you'd be surprised at how often it's not true. They will not use a sample unless they know they're going to get something out of it. And they basically create these mock-ups with similar samples to prove to themselves that with this sample, we can get something out of it. And only once they do that will they move forward. They told us a story about how they had tissue samples that had been in formaldehyde and then were like encased in some sort of plastic. And no one had ever gotten DNA out of a sample like that. And it took them a year to figure out how to do it. And they kept trying and they kept failing. And then finally they got it. And then they got it again. And they got it again. And they got it again. And then they tested it. They got the sample. They solved the case. So if they don't think they can get anything out of this, they're not going to test it. And Murdaugh just have to live with it. I think they probably will. And it's going to come back to one of 1,000 random people. It's not going to have anything to do with the crime. Here's the thing I'm pretty sure of. When you shoot somebody with an AR, a rifle, from distance, they didn't scratch you. There wasn't a struggle over the gun. You were killed
This is just a sideshow.
from distance. Total sideshow.
This was just a sideshow. And here's the funny thing. Othram is not some like public resource that anyone can just send their things to. It costs money because this is really expensive research that they're doing. And so I just think it's funny in one breath, they're like, we have to send this to Othram, knowing that they're not going to get anything from it and it's incredibly expensive. And then on the other breath, as they're talking about Charleston, is that their client has no money and is broke. Those are their words about Murdaugh. Our client is broke. That's not me making light of the situation, because
I'm sure somehow the people of South Carolina will end up paying for Othram to do this.
I'm sure.
So finally, the judge deferred consideration of Murdaugh's motion to dismiss the indictments. This was a newsy headline-grabbing filing the defense made based on some allegedly false or misleading testimony presented to the grand jury. They're going to have another hearing on November 13th. She'll deal with that there. She will deny the motions. It's going to be my prediction. This is not a 60-40 or 70-30 prediction. This
100%.
is a 100% prediction. Silly argument. A couple misstatements by the case agent in grand jury are not going to lead to a dismissal. And guess what? Even if they did, you know what they can do? They just go back to grand jury and re-get the indictment. It's a complete waste of everyone's time. So that will fail. The retrial remains scheduled to begin April. Judge, if you're listening, if you could push that back to like June-ish, that would be awesome. Like
Then our kids are then out of school.
Or, consult with me, and I'll let you know when spring break is. We might need to move it up a week or two.
It's going to be longer than a week. But
I know,
maybe...
a week's a week.
Wait, if the judge is listening, can I just throw in something?
Of course. Yeah.
Charleston's nice. But Alabama,
there you
super
go.
inexpensive. Super inexpensive. We're very friendly here. And accommodations are just... Nobody visits here, so our hotels are very inexpensive.
Yeah.
And we have...
spring?
It's the springtime.
You
You
come
have
to
the Atlanta
Tuscaloosa.
airport or Birmingham. We have so many airports to choose from.
No one here has heard of the Murdaugh case.
Nobody here has heard of Murdaugh.
Easy peasy.
There you go.
Or we could go down to Mobile if you really just want to do it on the beach.
There you go.
You know?
So it has a feel of
Fair
Charleston.
Hope. There you go.
We'll
It's
stay at
like
the Grand
Charleston.
Hotel.
Yeah. I mean, hey.
Okay, now we're just losing it because we followed this case for so long, and I'm just beginning to feel the delirium that will set in of covering that trial, which I'm really excited about.
I go back because on the one hand, I'm like, do we really need to cover? We've already covered this trial. Do we really want to do it? But on the other hand,
It'll
I'm
be
like,
so fun.
we
You know
totally
why
gotta
it's so
cover this
fun?
trial.
Because I really like Creighton Waters.
Creighton
I want to
Waters
see how
is
he
great.
presents it again this time.
And honestly, Pootie Poots, I mean,
he's great.
I didn't agree with Pootie Poot and the other guy. He kind of gets lost in the, I didn't agree with them, but they never made me angry.
No.
That's the thing. Like, that was just good lawyering in that case. Like,
Yes,
good
it was.
lawyers doing their thing, arguing for their client. Very little, like, collateral damage. They weren't accusing innocent people of doing it or anything like that. It wasn't like Delphi turned into, or the Karen Reed case.
It was just good old school lawyering with great Southern accents.
Great Southern accents. So there you go. So I want to know from you guys. So as Joe points out, we did Karen Reed twice. We did Karen Reed the first time on the main podcast. We did Karen Reed the second time on Legal Briefs. If we do Murdaugh, should we do it on the main podcast or should we do it on Legal Briefs? Let me know what you think.
I will say the Clancy case did so, like, I think more people naturally listen to it because it's been around longer.
Bigger
really.
reach.
And honestly, like Legal Briefs, people forget how to search it because, like, it's not that descriptive, whereas we are the prosecutors. So I feel like these trials might find a home on the main feed.
Yeah, that's what I'm thinking too. I just miss doing the other cases.
I do too. You know what's going to have to happen? We need to quit our
Prosecutors.
jobs and be able to
Trial.
do trials and other cases.
There you go.
Darn.
I already quit my job. I'm just saying.
I know.
Anyways, well, I got nothing else to add. It was an interesting week once again in true crime. It was nice to take a break from Lindsay Clancy, and we'll just see what else is going on.
Indeed. This was a very nice break from talking about Lindsay Clancy. I told Brett, I was like, we need to talk about it today because who knows what's going to happen in the Clancy trial this week. So we may not get to, like, these are important updates in important cases that obviously we've been following. So I'm glad we were able to do this on a weekend.
Yes, absolutely. And thank you to so many who joined us. Do you want to answer a question?
Let's do it. We have time. It's not a 2-hour episode.
It's not. I know. It's so funny. When we do these now, it just feels so short. It's like, wow, we've only been talking for 40 minutes. What's the...
So easy.
We've gotten several that come in lately on... Oh, here's one. Somebody thought it was funny that you called it Peabody.
Guys, every one of my Yale friends is like, yeah, it's Peabody. What else would it be? So none of us knew in New Haven.
Did you see someone wrote in and confirmed that...
Yes, I felt very seen that in New Haven, it is, in fact, Peabody, and in Cambridge, it is Peabody. I still think that sounds funny.
This is a question that needs like an entire legal briefs, but I'll go ahead and ask it now anyways. Okay, this person lives in Austin, Texas. The state has recently passed a law that the 10 Commandments must be displayed in each classroom. I don't know if it compels it or not, but that's beside the point. How the heck is this legal when the Constitution specifies a separation between church and state? What am I missing? Thanks, and love y'all. Well, first of all, you're not necessarily missing anything because there are Supreme Court cases that pretty clearly say that about the 10 Commandments. And actually, specifically about
the 10 Commandments.
Yes. Now, you have to remember, though, this is a time of transition and change in the law. The Supreme Court is different than it used to be, and so what we're seeing is a lot of challenges to these old statutes. This particular statute in Texas has actually already been challenged all the way up to the Fifth Circuit in a very closely divided en banc opinion, said that it is constitutional. So probably that will end up in front of the Supreme Court. Supreme Court's going to decide. It's a little bit more nuanced. The Constitution doesn't actually say separation of church and state in the way we often talk about it. So the question is this, what is it? Congress shall make no law respecting an establishment of religion,
right? So
or
is it establishing it? It's not that you can't have like any talk of religion and vice versa. So it's actually a very complicated. This was like my 1L moot court was about.
Mine too.
Look at that. Yeah. I mean, because it's a fascinating question, but the kind of common misunderstanding of separation of church and state is that there's like a wall and you're not allowed, like once you enter the public schools or the public sphere, you're not allowed to talk about religion and vice versa. That's not the case. It's about establishing it so you can celebrate all the religions and make it a free for all religion place. But this 10 Commandment question specifically, it's not like an old archaic precedent either. I think this is like from 10 years ago. This is going real fast. This is not from the 1800s.
Of it is relatively recent. Yes.
Like I think actually 15 years ago, because something like that. It was while we were in school, because I remember when this was happening, and Alabama, for example, had to take down the 10 Commandments, I think, in the state capitol.
So interesting things about this. It was the Alabama Supreme Court. Interesting things about this. Number one, so the reason prayer in school, 10 Commandments in school typically are not allowed is not because of a quote-unquote separation of church and state. It's that children are particularly susceptible, and so it's like an added thing. It felt, and if you read the Supreme Court cases on it, they talk about this. It's like, so for instance, Congress prays before every session. And the Supreme Court said, no problem at all, consistent with our long-standing inclusion of religion in public events. And it's a bunch of adults. It's not coercive. Fine. School's a little different. School praying before class, it's children. It may feel more coercive. Moments of silence where you can do whatever you want in school, those have been approved. A lot of kids pray. A lot of kids stand there. A lot of kids don't do anything. But so it's actually a much more nuanced, difficult question than maybe it first appears. Now, look, the Fifth Circuit is clearly flaunting Supreme Court law. There's no question. Under the current Supreme Court law, you can't do this. Now, the specifics of this may also be I don't know that it's required. It doesn't involve state money. It's like if someone buys you a copy of the 10 Commandments and gives it to you, you can display it in your school or something like that. I have to look at the exact specifics, but this will probably go before the Supreme Court. We'll probably do a legal briefs on it. Great question. I can understand why you would be confused about that. Okay, I've already said this. We had the extortion. Is the 5-star review extortion?
Oh, we've answered that question.
We got to follow up with bribery.
Okay. It's not bribery.
Are we being bribed to answer the questions?
Are we being bribed?
Because they're leaving a 5-star review.
Doesn't bribery have to involve some sort of like...
Yes.
Yeah, they're not giving you anything.
Yeah, like you got to be, once again, getting something...
And so it's like you're going to get a free parking pass or something like that.
I'll say they tried. I'll give them
a good job.
They said it affects third parties, like potential listeners and sponsors who see the rating. So you're like artificially inflating the rating. And I just say this. I would say
AI bots.
Yeah, exactly. AI bots see it. I appreciate that's some good lawyering right there. That's what lawyers do.
Use your brain.
They think about it. They try and come up with things. Great job. No is the answer. So it's not bribery.
You're good. You should feel great about leaving that 5-star review. But I love that question. Look, we answered that without an additional 5-star because you only get to rate one time. So we will answer all the questions you want.
Yeah. So, all right.
Well, this has been awesome, guys. As always, let us know what you want to hear about on Legal Briefs. This is where we try to cover true crime news in real time, break down the headlines that may or may not just be clickbait for you. You can email us at prosecutorspod@gmail.com. You can find us on all of the social medias at prosecutorspod. And we can't wait to dive back into the Lindsay Clancy trial, which we're covering on our other podcast, The Prosecutors. So if you haven't been following, come join all the fun, she said sarcastically. Anything else, Brett?
No, it's just always nice to take a break from the Lindsay Clancy case. It's really interesting, factually and legally, but it's tough. It weighs on us. So these are fun. This is always fun. If you got questions, things you want us to talk about, shoot them to us. We're always happy to do that here on Legal Briefs.
But until next time, I'm Alice,
And I'm Brett.
and this is the Prosecutor's Legal Briefs.
No.
Did that interview that's probably going to air in like 30 minutes.
Yeah.
Every TV thing is different, but this one was so, because it was, I guess I've never done pre-recorded before, and I didn't capture that it's just spliced and diced. So literally it was like question about Luigi Mangione, and then the like next question, which you would think would be a follow-up, would be about like Murdaugh. And like, it was just very like jarring. Like, do you lead up as a person? Are you like, well, since we're talking about Murdaugh, or do you just like go with it?
Hello, and welcome to Pluto Phone. If you know the name of the movie you'd like to see, just stream it for free on Pluto TV, where all your blockbuster favorites are landing all summer long. Catch Anchorman, The Legend of Ron Burgundy.
Fantastic.
The Matrix Trilogy.
Welcome to the real world.
Mean Girls.
Shut up!
Titanic.
I'm the king of the world.
And so much more. For showtimes, press nothing. They're free 24/7.
That is so fetch.
On Pluto TV. Stream now, pay never.
Sleep Number's new collections are designed to adapt to the changing nature of your life and your sleep needs. Whether it's the personalized comfort of the Comfort Mode mattress, the targeted pressure relief of the Comfort Next mattress, or the Climate Collection that actively cools or warms to help you fall asleep and stay asleep.
And now, all beds are on sale during our biggest sale of the year. Save 25% on the new Comfort Next Luxe, plus free delivery on any mattress. Ends Monday, only at a Sleep Number store or sleepnumber.com.